the suspension is now over and we're back in session. I recognize Senator Boyce.
Thank you, Mr. President. Good evening, colleagues of this honorable chamber. Mr. President, I had no intention of speaking today or tonight, but having been egged on by friends from both sides, sir, and from within the independent quarter, I thought it prudent to add my small commentary, sir, to the discussion, and perhaps to bring a perspective that is able to straddle both sides of the debate that we have seen so far, sir. And, sir, this process, I would like to start by taking a step back and looking less at the contextual context. And for lawyers, as you will be aware, sir, that has a different meaning. But just simply looking at the purpose of the legislation, which we're debating today, sir, and also looking at the purpose of the Severance Act as a whole. And I think if we conduct that exercise, Mr. President, we might be able to place ourselves in a position whereby when the time comes to do what is required later on, we be able to find some perspective which would allow us to make what choices we have to, sir. So, sir, the purpose of the Severance Act, and I'm going back to the original, sir, is to provide for the making by employers of severance payments to employees. And let me say how I can say that is the purpose, because that is the purpose of the legislation as determined by the judges in this country, sir. The locus classicus is the case of, as you well know, sir, AGARD, the Court of Appeal, sir, in which the purpose of the Severance Act and the subsequent legislation was considered in detail. Indeed, a recent decision has been handed down, sir. I was a party to it, so I wouldn't cite it, but it was we can say it was a favorable decision, sir. And, sir, if we look at it in relation to the purpose of the Severance Act, sir, and the legal jurisprudence which considers to be severance as payments which are triggered by various states of economic affairs. So if we recognize, sir, that the Act provides for the making by employers of severance payments to employees, sir, and that process is triggered by a state of the economy, sir, or alternatively, if the dismissal of the employee is attributable to the state of the economy, Mr. President, that severance comes into play. So what we view as a right, perhaps if we look at what the legislation says, we recognize that this is a payment which Parliament has prescribed, is given in circumstances. And those certain circumstances are circumstances which speak to economic affairs. So when I look at the legislation, Mr. President, from this perspective, and I recognize it being given by Parliament, this is a legislation which legally can be subsequently amended by Parliament, Mr. President. The question, though, as we get into the rub of the discussion, is the basis on which the amendment is now being sought. Can we say, sir, that there's a state of economic affair which has resulted in dismissal, sir? Can we say, sir, that there are some conditions which trigger an examination and a discussion of the existing provisions which govern these circumstances? That answer, sir, I would submit, is self-evident. So the question is that the reason which is set out by the leader of government business, who, and I am paraphrasing, so forgive me if I err, is ostensibly to provide breathing room for employers and allow them a longer period by which to utilize the layoff and short-time mechanisms. And the aim is to hopefully to preserve the cash resources of these employers so as to ensure survival. Can we disagree that that is a goal which falls within the ambit of the legislation, sir? I don't think we can. Can we say, sir, whether from a totally impartial basis on which I have to view these things, sir, that is one which does not fit within the confines of parliamentary duty as well as legislative consideration? And we must always remember that all these acts that we take are subject to subsequent review by the courts and, of course, by the people of Barbados. We will be judged eventually. Hopefully we do what we think is right, but at the end of the day, decisions have to be made, and we try to make those decisions, sir, in the best interest of the people of Barbados. Now, sir, in seeking to provide this space for the employer, employees will be impacted. Because in giving the employer more room to operate, employees are forced to wait longer to trigger their severance obligations. We've heard the discussions about that. And during this longer waiting period, they will be subject, sir, to the ravages and the reality of having to deal with the layoff process or the short-time process. So there's a clear risk, sir, that what we're seeing in providing this space for the employer, employees would be impacted. And let's be frank, there's a clear risk that in providing this breathing room, there are unscrupulous persons who would seek to manipulate the offering. That is life. What I can personally attest to, Mr. President, what I can personally attest to is I know of employers who are civic-minded and who want to carry on their operations, sir. Civic-minded employers who are willing to carry on their operation and want to carry their organization through this period and would appreciate the breathing room, Mr. President. So, how is this gift of breathing room to be mitigated against the risk of it being abused and the risk or the clear impact it has on the employees? What steps can be taken to protect these employees and to protect against its abuse? Questions are therefore posed, Mr. President. What investigation is done to ensure that when these claims are made by the employers under the heading of COVID impact, that their validity is determined? What is the investigation? Which body has that power? What checks will be done? What balances will be put in place? Or perhaps we say this, sir. The Bible reading yesterday, Senator Dr. Rogers would tell you, there was a line which said, the rain falls on the just and the unjust, Mr. President. Maybe that's a coincidence. But the point is, if the good book recognizes that the rain falls on the just and the unjust, sir, we recognize that there are persons who would abuse this space while recognizing that there are persons who will benefit, sir. And what we have to do as far as possible, and I heard in reference to the ministerial order, sir, is to make sure as far as possible that care is taken with regard to the terms of the implementation. Not only the terms of the implementation, Mr. President, in ascertaining whether or not the organization truly was impacted by the factors set out as determined by the legislation, that is, i.e. COVID, but to ensure, sir, that as far as possible, the workers who are impacted by having to go through the layoff and the short pay payments are given some form of priority to access, because we recognize the situation with the fact that NIS's organization is subject to a huge strain in light of the number of claims that are being made. For myself, Mr. President, this is a question which can be easily answered in terms of my position. I can take comfort in that this is a short-term proposal, and after July 31st, we will see clearly what tale time tells. The government is given the benefit of the doubt, sir, in these circumstances. This is my personal perspective, Mr. President. I think everyone is here has heard me state how that perspective is viewed, and in terms of the different political, if I call it that, science narrative that I use to define it. And a certain amount of trust is given to deal with crises, sir. If, however, and I have listened, and I must commend, sir, I think Senator Moore, sir, spoke to my heart. Sorry, let me clarify that, because my wife might be listening. Senator Moore spoke to my heart in terms of the points which were made in terms of the considerations from a union perspective, sir. And that is something we have to be mindful of. But I wish to say this, sir. After July 31st, we will be able to see what the tale tells, sir. And at that time, we will make the assessment. And with those statements, sir, I wish to conclude my contribution on this bill. Thank you very much, Mr. President.
Thank you. I recognize Senator Tate as our next speaker.
Thank you, Mr. President. Mr. President, this evening, tonight, my comments are going to be focusing on the legislation itself and the drafting, as usual, as I tend to examine the legislation and how the applicability of it. But before I get to that, I just want to say, I listened to Senator Boyce, and he spoke about balance. And Senator Holder brought a perspective from the employer's perspective. And for me, I find that I feel the need to say all employers are not evil. I think that needs to be said, because there's an emphasis that is happening here, and I'm not criticizing anybody. I believe that what has been said this evening and all day in relation to the evil that is occurring in our society as it relates to the employee, it needs to be said. What concerns me is that we keep talking about it, and if you listen carefully, particularly to our trade unionists that are in this chamber, they seem to continuously and continually refer to the same employers all the time. So my thing is, it's time to get something done about these people, who are breaching the laws of this country. But we have to be careful, because as we seek to do that or take that on, it is imperative that mixed signals cease, because some of the players in the evil employer world are seen in the company of high-level officials in this country. If we have that going on, no wonder they feel that they are above the law and they can get away with all kinds of quote-unquote murder. The picture is finished, but it's still going on. How to get away with murder. It concerns me that we have this ongoing dialogue about persons who feel that they do not have to comply. But slavery is done. Black lives matter. Bajan lives matter. Employees matter. But in the midst of this, we must not forget, employers matter too. And as an independent senator, my remit is to look at things and look after all constituents of Barbados. So as we focus on the employee who, depending on your viewpoint, is the disadvantage, we have to remember the employer who, as Senator Holder says, has to be given an opportunity to stay in business. What concerns me when we have these type of issues is that we always seem to wait to the last minute to deal with things that ought to have been dealt with before, so that we can look at it holistically, globally, properly, efficiently, and get it right. There's no excuse for this legislation. And let me just say, yes, Senator Holder said we're not perfect. I get that. I'm not asking for perfection. But we have a piece of legislation that has a short life currently. The 1st of June to the 31st of July. That's 2 months. But today is the 17th and we haven't passed it yet. So we've already lost from the 1st to the 17th. So there's a potential that there are people sitting down waiting for this legislation to pass so that they can make their claim pursuant to the provision of this sunset legislation. But here's the thing. We pass it today, it's signed tomorrow, it's law. We don't know what's the procedure. Because the minister may make an order with respect to investigating and settling claims. Kadir, it is too short a life not to have had the details of what is supposed to happen incorporated in a schedule in the body of the legislation wherever. Mr. President, sir, it is too short a lifespan. So we pass it, somebody wants to make a claim, what's the procedure? And if you look at the legislation, Mr. President, there are a lot of conditionalities that are attached to this legislation. So, on page 4, where we have subclause 3 that speaks to the new 6A, where an employee has been laid off or kept on short time, commencing at any time between the 1st of March and the 30th of April, etc., etc. But subclause 2 speaks to a different type of employee. Here now we have an employee who was laid off or kept on short time before the first day of June as a result of restrictions on international travel due to the declaration of a public health emergency and the consequent restriction in the operation of business imposed by the making of the Emergency Management COVID-19 Curfew Numbers 125, Directives 2020. So, in order to qualify to make a claim, you have to fall into certain categories of employee. Certain categories of employee who was impacted by coronavirus in specific ways, Who checking for that, Mr. President? What's the procedure? Who's going to determine if we have, God forbid, unscrupulous employees, fraudulent employees, dishonest employees, non-productive employees, employees who trying to get severance so that they can go and start their own business employees? Who checking for that? We don't have a procedure because subclause 6B says the minister may by order prescribe the procedure for investigating and settling claims. Now here's the thing. It suggests here that something is to come. Today is the 17th. So when it coming? This ends on the 31st of July. But Mr. President, what confuses me is that at subclause 4, which speaks to 7A5 on page 7, we have subclause 5 on page 7, and then on page 8 you will notice, sir, that there's reference to tribunal in subclause C on page 8. If an employer gives a counter notice within those 7 days, etc., etc., in pursuance of the notice of intention to claim is referred to a tribunal, that period of 3 weeks after the tribunal, for the purposes, any appeal against the decision of the tribunal. So he is to prescribe procedure for investigating and settling claims, but we're still hearing about a tribunal. But it doesn't seem as if it's to be any of the 4 severance